Good afternoon, everyone, and welcome. We're doing a webinar today on the Pregnant Workers Fairness Act, and that was effective June 27th of 2023. And I don't know about the audience, but I just want to say that this weather has sure got me in a pleasant mood today, and I have greatly value the cooler weather that we've been experiencing for a couple of days. So I really appreciate everyone participating and hope that you've had a great day today and that you'll get a lot out of this webinar. Now, my webinar and podcast partner, Corbin Granger, is joining us now. She's in listen mode. And so I wanted to just remind you all that Corbin and I deal with a lot of human resources, benefits, and compliance matters. And we work as a team on a lot of those things. And we do interact and deal with a lot of our clients on a pretty regular basis. And so I very much we both value working with our clients and encourage you that if you have questions or problems or things you'd like to discuss in those areas, please do not ever hesitate to contact us. Now today we're going to do, obviously we have the questions available. If you have a question, just feel free to put one in the question box and we're going to deal with those at the end. I think that's the most efficient way to do things. So again, welcome and we're glad you're here today. Now, my name is Barbara Jennings, and I'm a human resources consultant here at Towne Benefits, and my background is in human resources. I spent over 30 years as a human resources manager, and as you might imagine, in the 30-year period, a lot of things change, and so I've seen a lot of stuff change over the years, and that's one thing I bring to the table here with our clients is a lot of practical experience in managing people and benefits. Now, remember that I am not a lawyer and nothing that I say here today constitutes legal advice. Sometimes when I'm dealing with our clients and a client will ask me a question and my feeling about it is, you know what, I think this is a situation where you need to seek legal advice. And so sometimes that's my answer to, or that's the best I can do for someone, because there are situations, as many of you probably know, where talking to a lawyer is definitely the best idea. So keep that in mind as we go along today. My perspective is more kind of common sense, people management, HR type of management analysis, and kind of like what would I do if I were in this situation. And so that's how I look at this new law is how can I apply this law to my company's operations? What can I anticipate might come up with this new law? It might take employees a while to figure out that this new law is in effect. And so it might be interesting to know that you might be thinking about how I'd be prepared if someone comes in and asks for an accommodation or that sort of thing. So anyway, without further ado, we're going to get started with the actual presentation. Now, first of all, I thought it might be interesting to do kind of a brief history of the federal pregnancy and lactation laws. And I have to keep saying federal because remember that individual states can pass their own laws, and quite a few states have passed laws pertaining to pregnancy and lactation. And so just keep that in mind. And we're going to talk about that a little bit more later. But anyway, thought you, particularly newer folks, might not realize what a lengthy history pregnancy type matters have had in the field of employment law. So first of all, when you think about pregnancy, it sounds so easy. Oh, someone's pregnant, that means they're going to have a baby. But when you think about pregnancy and the workplace, there's some complicators that go with that. So generally, pregnancy is, it can come with some conditions, like you can have non-disabling pregnancy limitations. Anyone who's ever been pregnant, and I certainly have, morning sickness, swollen ankles, backaches, that sort of stuff. But many women are in the workforce and they just keep on trucking until close to the time of their due date. And then you could have some potentially disabling medical conditions. So for example, there's a condition called preeclampsia, which is very serious. And that might fall under the Americans with Disabilities Act. Sometimes I think that gestational diabetes, which many people manage perfectly well and continue being able to work, that can send some people home on bed rest for a while. So employers need to be aware of those things Then, of course, you have the actual childbirth, and then you have the recovery, and then you have bonding time, and then you have lactation. And so it's interesting because over the years, no one has ever passed one single law that covers all those things. And so what we end up with is this kind of hodgepodge of laws that kind of pick apart one at a time. So here's the quick history. Everything kind of started, the ball kind of got rolling with the Civil Rights Act of 1964, Title VII specifically. And Title VII created the idea of protected characteristics. I know you might hear that sometimes. You say that it might be a truth to say that discrimination is only illegal in the workplace when it affects someone with a protected characteristic. And that would be, originally it was race, color, religion, sex, national origin, and that sort of thing. And over the years, different laws and different amendments have broadened the definition of a protected characteristics to include age, age discrimination, disability, sexual orientation, that sort of thing. So some of these laws have kind of been morphing as time goes by, but remember that date of 1964, that's where it all started. And originally, the act applied to employers with 100 or more employees, and over the years, that was decreased to the point where we're now at currently at 15 or more employees. Now, the reason I included Title VII in here is because pregnancy is not an original part of Title VII, but this law was the first step toward employment discrimination or protection, based on sex, because you'll notice that it's spelled out in the original act that you can't discriminate against employees based on sex. And pregnancy certainly falls under gender or sex. So that was the starting point. Now, from there, we went from 1964, we jumped over to 1978. Now, here was a law that now actually said you can't discriminate against women based on pregnancy. But that sounds good, and that was a good start. But what that act did was it required that employers accommodate pregnant employees in the same manner that they accommodate other employees who are similar in their inability to work. So, for example, this law brought into being the idea that whatever you do for someone who's having, let's say, back surgery, you have to do for someone who is pregnant and for pregnancy-related issues. So you couldn't discriminate. You couldn't tell an employee, no, sorry, we're not going to give you any time off, despite the fact that you give people time off for other conditions. So once again, we have this little kind of footprint along the path to, full acknowledgement of pregnancy and what all that entails. Now, jump forward to 1990, and you got the Americans with Disabilities Act. And as I said at the very beginning of this, that pregnancy is not a disability. It's something where most women are perfectly able to work and live their lives without being impaired as the ADA defines it. So pregnancy, the Americans with Disabilities Act was kind of a non-event for many, many pregnant women, but it did cover and does cover those serious health conditions, for example, the preeclampsia and sometimes gestational diabetes and other types of problems that arise that would rise to the level of being a disability. So in that regard, yes, some people are able to use the ADA and those protections, but many were not. All right, now let's move forward to 1993. That, of course, is the Family and Medical Leave Act. And while it does not pertain specifically to pregnancy, it does do something for the first time, which is to guarantee that if a woman is otherwise qualified to take family and medical leave, then she will be covered for up to 12 weeks for the birth of a child, to care for a newborn, and to bond with the newborn. So that was a very welcome piece of legislation for a lot of women to know that their job was protected and their insurance coverage was protected for at least 12 weeks. Then we move forward to 2010, and here we're looping in now the lactation component of pregnancy. And so this was part of the Affordable Care Act, and it created the requirement that employees who were lactating would be able to have a private space and time in order to, pump breast milk. Now, this only applied at that time to non-exempt employees. And so you note that that protection only applied there. And so your exempt employees were not covered by this act until we got to the Pump Act of 2022. Now, that's the most recent act pertaining to pregnancy and its associated events. And that kind of tightened up some of the requirements for breastfeeding moms. And the big thing it did was it began to cover most exempt employees. And so that was the biggie, is to provide for exempt employees as well as non-exempt employees. So now, 58 years later, if you go back to 1964, we get this new legislation called the Pregnant Workers Fairness Act. And interesting, I'll tell you what, I know that beginning in the 1950s, I want to say, we think about how many women were in the workforce then. And really, we've had this cultural and thinking shift about women in the workforce and pregnancy. And for women, let's say in the 1950s, which I think they comprised about 25% of the workforce. But, women were mostly like second income workers in the household. They had jobs, often part-time, where if they became pregnant or had children, that might be the point of departure for them from the workplace forever or for many years. And so really a lot of consideration at that point would not have been given to women thinking about how to accommodate them in the workplace. And so you go, to the 60s, and a greater number of women were in the workplace. And so beginning with the Civil Rights Act of 64, you kind of begin to see those changes of the various protections. And then, beam us forward to now, and of course, women comprise, I want to say, about 48% of the workforce. So nearly 50% of the workforce is female. And women are occupying a much broader range of jobs. Many women work full-time. Many women are in executive positions. Many women are in the C-suite. And so you can kind of see this evolution of these laws as, again, it took 58 years, but you can see how they've evolved as women's roles in the workplace has evolved. I tell you, it makes me think of an anecdote about my father many years ago when the television was new, and how our family was late adopters to getting a television because my dad thought it was a fad and it would never last. And so it kind of reminds me of maybe the thinking back 50 years ago that nobody could foresee where women would be in the workplace to the extent that they are. But this act is kind of what I would call the last puzzle piece, I think. After we talk about this for a few minutes, I think it became clear to me in preparing for this webinar that I can't think of anything else that could be added to pregnancy protections except for, at some point in the future, the federal law that covers paid leave for childbirth and recovery and that sort of thing. But some states have already done this. But anyway, if we are, that's kind of the last frontier that I can see for the changes in coverage for pregnancy and childbirth. So now it applies, this new law, the Pregnancy Workers Fairness Act, applies to employers with 15 or more employees. And so that's a pretty low threshold. And it applies to both employees and job applicants and requires accommodation related to pregnancy, childbirth, and related medical conditions in the same way that that considers requests for accommodation related to actual disabilities under the ADA. An important difference, however, is that the employee under the PWFA, the Pregnant Workers Fairness Act, the employee does not have to have a disability as defined by the ADA. And this act introduces this new concept called known limitations. And that is, under the law, a known limitation is something that the employee has informed the employer that she is experiencing. So for example, if you have an employee that comes to you and says, I'm pregnant and I'm having morning sickness, or my feet are swelling, or I'm having backaches, or I feel like I need to sit down for a few minutes, every hour or something like that. Once the employee approaches the employer about that, now it's a known limitation. And I also kind of think that even though this is not part of the law, as an employer or as a personnel director or a human resources director, you think of all the conditions that just kind of everybody knows about. All these things are just kind of generally known to be kind of a part and parcel of being pregnant. And so just remembering that when you hear a pregnant employee talking about something like a condition like that, that may trigger you to go into action about thinking, okay, is the PWFA going to apply here? So just be aware that there are things that you need to start thinking about when somebody starts talking about having limitations. All right, so the PWFA only applies to accommodations. Now, we've talked about this history of all these other laws. They all cover all the other stuff. And so this law does not change or take away anything from that whole list of laws that are still in place that have been happening over the past decades. And the existing laws that the EEOC already enforces that make it illegal to fire people and discriminate against workers, et cetera, are all still in place. Now, one thing that, like the ADA, that's required is that you do have to provide reasonable accommodations under the PWFA. These are, I love it when the EEOC or some other body uses language like, it's like the ADA, but different. Okay, so yeah, it has some similarities to the ADA, but different because pregnancy is a temporary condition. And what is deemed reasonable under the ADA might not be reasonable under the PWFA. So for example, for an employee who is seeking some type of accommodation under the ADA that might mean some type of like physical change to their workspace, workplace that, might involve equipment or construction or something like that, a modification, under the ADA, that might be reasonable. Under the PWFA, that might not be reasonable because, expenses, undue hardship, and that sort of thing come into play in the PWFA as well. So just be aware of that generally speaking, with the PWFA, you're talking about slightly lower grade accommodations. But, honestly, this law is new. More guidance is probably going to come out over the years. And unfortunately, this is also going to play out in the courts. Many of these laws have been modified by court rulings. And so this will be the same way. And so one of my purposes today is to try to keep you and your company from being one of those court cases that plays out to clarify the law. So the other thing that is required under PWFA is the interactive process. And that should sound familiar to everyone because the interactive process is required under the Americans with Disabilities Act. And so the fact that it applies to accommodations apply to both employees and applicants is meaningful and important. All right, so who and what does the PWFA protect? The PWFA protects employees and applicants of covered employers that have known limitations related to pregnancy, childbirth, or those related conditions. And we talked about the term known limitation, meaning physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions that the employee or the employee's representative has communicated to the employer whether or not such condition meets the definition of a disability. And as we talked about before, the PWFA does not replace federal, state, or local laws that are more protective of workers affected by pregnancy and its related situations. Now, this is probably a good time to say, and I may end up repeating this, that the law that is the most generous, good rule of thumb, is state or federal, whichever works to the greater benefit of the employee, that is in all likelihood the law that you're going to follow. Okay, so you're going to benefit your employee to the maximum possible by following the most generous law. We don't have much. There is a little more protection in the Virginia Human Rights Act for pumping moms than in any other legislation. Somewhere there's a cap on the ability to pump breast milk at 1 year under the federal law, whereas the Virginia law there is no 1 year limitation. So it's probably quite obscure and most people probably don't encounter that. But anyway, that's a case where the state law is a little bit more generous than the federal law. Okay, so we talked a little bit about the fact that reasonable accommodations are required. So what would be an example? This is kind of the brave new world of the PWFA. An example of reasonable accommodations would be something like the ability to sit down, to drink water, to have food or water at your workstation, the pregnant employee's workstation. Perhaps being reassigned a closer parking spot so the employee doesn't have to walk as far. Then you have the issues with flexible hours or possibly remote work that could be considered a reasonable accommodation, for one of these known limitations. And to receive appropriately sized uniforms and safety apparel. And when I first saw that, I was like, what? I didn't even think about the fact that in, really quite a few jobs, you have uniforms that are required. And when I started reading a little bit more about this, my eyes were open to the fact that a lot of times with uniforms, what an employer will do is just give a pregnant employee a male uniform, because it might be roomier and bigger. But then you run into this issue where the sleeves might be long, which could create a safety hazard. And so receiving a specifically designed maybe maternity outfit while you're pregnant, that might be something that would be considered a reasonable accommodation. The ability to take additional break times to go to the bathroom, to eat, to rest, that might be reasonable. To take leave time off or to recover from childbirth. Now, when I saw that, I'm like, okay, that's a little vague. And I got to thinking, wow, what could that mean? Well, obviously, if you have an employee who qualifies, and if your company meets the over 50 threshold for being an FMLA employer, you've got your 12 weeks out there that would apply to the employee. But this just kind of open-ended, take leave or time off to recover from childbirth. What does that mean? I couldn't really find a lengthy explanation of that. And so as an employer, you need to be aware of that. And I guess my default position would be, how do you treat other employees for other medical conditions? So for example, if you allow employees to be out, let's just say, pick a figure, for 4 weeks to have some type of surgery or chemotherapy or something like that, then if an employee asks to take that 4 weeks off to recover from childbirth, I can see that being construed as a reasonable accommodation because you're treating that person consistently with other people. So that is going to be one of those interesting things that you might see end up in court cases, or it simply might end up in further guidance from the EEOC. Most of these laws, you end up with Q&As that are published fairly regularly while we're adjusting to them and while new stuff is kind of being thought about. So we may well see EEOC Q&As come out that might cover this. So but just kind of be aware that that's out there. Another reasonable accommodation might be that the employee would be excused from strenuous activities and/or activities that involve exposure to chemicals that are not safe for pregnancy. So be aware of that if you're an employer that has that sort of environment, that you may need to be prepared in some way for an employee to ask for that as an accommodation. All right, now here's a list of do nots or cannots. Now, if you have a PWFA request, you cannot require an employee to accept an accommodation without that interactive dialogue, which in this little slide is without a discussion about the accommodation between the worker and the employer. So you need to actively discuss with the employee what they might need as far as an accommodation for their known limitation. You can't deny a job or a promotion to an employee or an applicant based on the person's need for a reasonable accommodation. And once again, as with the ADA, this is a qualified employee. So, you know, with the ADA and with this act, you are not required to give a job or promote an employee or an applicant who is not qualified for the job. So if they don't meet the essential requirements for the job, you do not have to think about reasonable accommodations. But if they do meet all that, and if someone, it's odd to think about an applicant, but you know, let's just say you have an applicant who says, oh, by the way, I'm pregnant and I have to sit down for 5 minutes every hour and put my feet up. Well, you cannot fail to hire that person if that person is the most qualified person for the job, just like you can't fail to promote an employee, you know, just because they make that request. All right, you can't require an employee to take leave if there's some other accommodation that can be provided that would let the employee keep working. So, you know, it could sound like the easy answer if the person says, I need to alter my schedule, please, as a reasonable accommodation and work from 9 to 6 instead of 8 to 5 for the next 4 months. It might be easy to say, oh, you know, just take your maternity leave now, just take leave. Well, you cannot do that if there's some other accommodation out there, and certainly a change in start times could be conceived of as a reasonable accommodation. You can't interfere with any individual's rights under the PWFA. So this kind of invokes the specter of retaliation. People have the right to certain things, and you don't want to interfere with that right. Oh, and here comes the specter of retaliation. You cannot retaliate against employees for seeking or taking a reasonable accommodation related to pregnancy and childbirth, and you can't retaliate against an individual for reporting or opposing unlawful discrimination under the PWFA or participating in some type of proceeding. Let's say another employee goes to the EEOC and claims something under the PWFA, and you have a couple of employees who witnessed some exchanges between the supervisor and the employee, and the EEOC is going to interview them. You cannot retaliate against those employees for taking part in those interviews. So just be aware of that. As I've mentioned many times, and Corbin and I have some podcast episodes that deal with retaliation. 50% of all EEOC charges have a retaliation component, and retaliation can pop up in all kinds of laws, the FMLA, the ADA, the Age Discrimination Act, now the PWFA. So it's something that you should be top of mind when it comes to administering, you know, your human resources administration, to just be aware of that. Some things to keep in mind, and this is important. The first one in particular, the PWFA does not require the employee to say any, quote, magic words, nor does it require a doctor's note stating that the accommodation is needed. So that's kind of the first thing to check off the list. Is the employee simply has the ability to come to you as the employer and say, you know, my ankles are swelling, I'm nauseated in the mornings, I have to stop and give myself shots twice a day because I have gestational diabetes. As soon as an employee begins talking like that, the employer should say, okay, this sounds like something we need to talk about because it sounds like something that could be covered under the Pregnant Workers Fairness Act. And then you initiate the dialogue and talk about what needs to be done. So critical to train supervisors to deal with these comments from employees so that they understand they can't just dismiss things. Nope, sorry, we can't do that for you. But that the supervisor may need to talk to human resources about how to have the interactive dialogue. So remember, no magic words. The employer needs to initiate the discussion. If they get an inkling that the employee is having pregnancy issues and needs to talk about it, and then no note required that the accommodation is needed. Now, as with the ADA, an interactive dialogue between the employer and the employee is absolutely essential. And also with the ADA, you should always document these discussions and the outcome and why this particular outcome was decided on. Because some of the accommodations might, conflict with your policies and your procedures. And you don't want to give employees in the workplace the idea that now there's been some blanket compromise on this long-standing policy, because now this person can do X, which we weren't able to do before. And that's why you want to be able to have documented why you made this outcome. So what we did was we set aside this policy for this employee under this circumstance, so that you don't just kind of get this free for all on people just out of the blue wanting these wanting that policy to be changed. Now, one other thing that occurred to me, kind of going back to the first bullet point, that it doesn't mean that the employee has carte blanche because the employee is pregnant and because the employee has a known limitation. And an example of that might be this. Let's say that you had the interactive dialogue with the employee and you came to the mutual decision that this particular thing, let's just say the altered work schedule, that yes, you're going to allow the employee to come in late every day. You're going to allow the employee to work 9 to 6 instead of 8 to 5 or whatever. And that's now going to be the regular schedule. You know it, you predict it. You don't need to, the employee does not need to have to show notes or prove anything or call in or any of that sort of stuff. That is not the same thing as you've come up with a fixed schedule and you've accommodated the employee. And now suddenly the employee, 2 days out of 3, is now tardy. She's not meeting the 9 o'clock schedule. That would be something you might need to go back and revisit with the employee and or apply whatever your normal tardiness notification is. So if you require people to call in, they're going to be more than 15 minutes late. That employee might need to be required to call in when she's not going to be there, instead of having people wonder where she is. And I hope you see the difference between those two. A regular schedule change is one thing, but now random tardiness is something different. And it's like when these new laws come down the pike, and even with the old laws, you don't want to be kind of so fearful about violating a law that you just kind of don't take any measures with employees. But on the other hand, you do know that you've got to accommodate these things. And so, as always, HR managers, as you may know, are highly esteemed by me because of the things that you have to deal with every day. And so you do have to walk the line between, maintaining your workplace in an efficient order and accommodating employees. So, that's where the common sense kind of comes into play. Now, hey, guess what? There's a poster. Surprise, right? Isn't there always a poster? So this is what the PWFA poster looks like. And so you can download it, post it so employees can see it and that sort of thing. All right, so just real quick, I'm going to do what's called the PWFA snapshot. All right, just real quick, remember that it applies if you have 15 or more employees. In most cases, it applies to you and your business. Applies only to the accommodations of what's called known limitations. And remember that known limitations are not the same as an ADA disability. You must have an interactive dialogue between the employer and the employee to come up with a mutual, workable, reasonable accommodation. And when you're having these discussions, keep in mind that this situation is temporary. Remember that a lot of times you're not even going to know that an employee is pregnant until 2 or 3 months into the pregnancy. And so really you might be talking about something that has to be done for 7 months, usually at the outside. But anyway, so when you're talking about these accommodations you have to make, just remember that they don't last forever. The reasonable accommodation must be made unless it actually will be an undue hardship. And the ADA and the PWFA share the same definition of undue hardship, and that the employee making the request does not need documentation of the known limitation from a medical professional. So I think, as you know, or anyone who's been in one of my webinars before, I've tried to make it clear that one reason why I include so much information on these slides is so that they can be reference materials for you to go back and look at later in case you can't remember, did she say this? That you can go back and have enough information to be able to help you. So I'm trying to come up with a real world scenario here to talk about just for a minute. So let's say you're in a medical office and one of your patient registration reps has come to tell you that she's pregnant. Now, the next week, her supervisor notices that without explanation, this employee leaves her station 2 or 3 times every morning before lunch, and she's often looking pale and appears to be tired. Now, if you've informed your supervisors about this, then this thinking that the employee is unwell, the supervisor may ask the employee, look, I've noticed you're taking these breaks. Are you okay? And the employee says, unfortunately, I'm really suffering from morning sickness. So that afternoon, the supervisor knows enough about the act to say, okay, we need to meet. And then asks, okay, what can I do to help you? The employee says that it only seems to affect her before lunch. I guess that's why for the most part, they call it morning sickness. But anyway, and over the weekend, she says she noticed that if she could nibble some saltine crackers and sip ginger ale, that really seemed to make her feel better. And then after she ate lunch, she was good, for the rest of the day. Now, unfortunately, this medical office has a prohibition against, being a public-facing organization. They don't allow food and drink in the patient registration area. All right, so under the PWFA, would allowing this employee to discreetly consume crackers and ginger ale at the workstation for a few weeks, would that be considered a reasonable accommodation? Honestly, almost certainly that would be a reasonable accommodation. The employer should document this series of events. Note that the employer initiated the dialogue with the employee, that the employee requested a specific accommodation without, there wasn't a lot of dialogue in the interactive dialogue. The employee asked for something that was a pretty easy fix. The accommodation was made, and now you need to just go back and document the record. You record the event and create a record of the policy exception that was made and why it was made. Again, going back to a few minutes ago, because you don't suddenly want this free-for-all, oh, now we can have food and drink at our station? No, we're making an accommodation, and it is a limited accommodation that's going to go away at the end, when the baby is born. So that is a kind of simplistic scenario, but I did think that was something that could realistically come up. And unfortunately, a lot of what you have to deal with is going to be more complicated than that. All right, so now I'm going to talk about some helpful definitions. There are really only 4 here. Kind of the difference between the ADA and the PWFA. The ADA defines a person who has a physical or mental impairment that substantially limits one or more major life activities, or this person has a history or a record of such an impairment, or is perceived by others as having such an impairment. And a major life activity is, the pretty big ticket items: self-care, seeing, hearing, eating, sleeping, performing certain manual tasks, and that sort of thing. So that's the ADA. The PWFA says outright, hey, it doesn't have to be a disability at all under the ADA. So the reality is, if you're talking about pregnancy of small scale when it comes to the known limitation, then you don't even have to worry about the ADA at all. ADA would only come in when you're talking about someone in the stages of pregnancy who experiences this major life activity issue, in which case the ADA could then kick in. So I guess in theory, a person could technically maybe be covered under both at the same time, but you're probably going to be way more common to encounter just the known limitations under the PWFA, and it's not going to reach the level of an ADA disability. All right, a reasonable accommodation. Now, under the ADA, reasonable accommodation does not have a strict definition. Any change in the workplace or the way things are customarily done that provides an equal employment opportunity to an individual with a disability. So some of these things may overlap. Remember your Venn diagram from your geometry class where the two circles side by side or three circles overlap, and there's this area in the middle. So some of these things under the ADA, like a modified work schedule, remote work, maybe changing some small things about the way the job is done, both of those might apply to the ADA and the PWFA. But a reasonable accommodation is just flat out not defined in the Act. The Act instead gives examples of accommodations that would probably be considered reasonable. All right, undue hardship. Now, under the ADA, an employer is required to provide a reasonable accommodation as long as doing so does not create an undue hardship. And the ADA goes on to say that an undue hardship is a significant difficulty or expense. The cost of an accommodation could be an undue burden, but so could the accommodation's duration, expansiveness, or disruption. An accommodation might fundamentally alter the nature or operation of a business, and that could be considered an undue hardship. And you could take into consideration the size of the organization and the affected facility, the overall financial resources, and any tax credits, deductions, or outside funding available. All right. So that's a pretty high bar. And the PWFA has actually adopted the ADA's definition of undue hardship. But under the PWFA, the hardship, you can decline an employee's request if you can see it's materially going to affect the operation of your business. And certainly a small employer you can see might be more affected than a larger employer if you have fewer people in each job. But this is one of those circumstances where I'm going to say, as an HR director, I would probably seek legal guidance before I turn down an employee's request as being an undue hardship. And I know that at some point in time that may not be necessary because we'll get some clearer evidence of what is undue under the PWFA. But for now, if it were me, that's what I would do. Now, the interactive process we've talked about pretty much exactly the same under both the ADA and the PWFA. You're basically going to sit down and you're going to have a conversation about how you can accommodate this person and hopefully work towards something that works for everybody. And remember that always, whether it's ADA, whether it's PWFA, the interactive process is just about as important as the accommodation itself. So don't skimp on your interactive dialogues with your employees, and don't ever skimp on your documentation. My suggestions for what you should do is, first of all, become familiar with the PWFA. Hopefully, I've given you really a lot of the information that's out there, because this is kind of like the info out there is pretty lean, but it's not that difficult. Most of this stuff you can just kind of turn to a list and think, okay, what's a reasonable accommodation? Just read the list of what is already out there and you'll get an idea of what type of thing you're going to be expected to do. All right, then update your employee handbook to include information on the PWFA. You can talk about known limitations, talk about the procedure. If you're pregnant, if you need this, if you need that, talk to your supervisor or talk to HR. Be prepared for an employee to come and ask. Really, really critical. Inform your managers and your supervisors about this new law, that it exists, how it differs from the ADA, how they need to feel free with your open door policy to come to HR to ask questions. In advance, be considering the types of accommodations that employees might seek in your work environment. They might be very different in different work environments. And so kind of be thinking about what could people ask for? If you're in a manufacturing environment, or if you have nurses, or if you have police officers and uniforms are involved, you might need to be thinking about, okay, maybe we should contract with some provider and get maternity outfits, or make it easy to order one, because obviously that's going to be a size-based issue, and that sort of thing. Be thinking proactively. And my final retaliation reminder, I already said that over half of all discrimination charges include a charge of retaliation. So keep your company out of trouble by being cautious when taking a negative action. And by that, a termination, a failure to promote, failure to accommodate, and that sort of thing. And before taking the action, it's always wise to make sure that the affected employee has not recently engaged in some protected activity, like taking FMLA is a protected activity. Complaining to somebody, the supervisor, about a safety issue, requesting an accommodation, that sort of thing. Real or imagined, a retaliation claim can be very costly, so always be aware of that. Link, this is the one that I found to be most helpful, was the EEOC PWFA Q&A link. And now I looked this up today to see if anything new had come down the pike, and it hadn't that I could find. It's really a pretty short Q&A, and most of what's in there is in this slide presentation. But honestly, about every other week, I'm going to be out there looking. A lot of the big law firms are doing blog posts on this. And if you just Google law firm blog post PWFA, and you should kind of keep yourself up to date as things develop. It's going to take a while, I think, for enforcement to kick in and for legal cases to be hitting the courts. But the law firms do tend to put opinions out there, which can be very helpful. Now, I have to put in a little plug for our podcast. If you are not aware of our HR on Mic podcast, we do release new episodes every 3 weeks. We try to cover things that employers are interested in. And unlike our webinars, which sometimes can run to an hour or so, these are shorter takes between 5 minutes and let's say 15 minutes on various topics. And we do release them the third Wednesday of each month. We also have an email address here. If there's any topic, and actually somebody just emailed me the other day a suggested topic that they might like to see a webinar on or a podcast on. So feel free, use that Towne Benefits compliance at TowneBenefits.com link to our email to just get in touch with us for any reason that you'd like. Just to say hi is fine too. We do love it when people let us know that they've listened to the podcast and they help make suggestions. That's very helpful for us. So I'm going to see now if we have any questions. Anyone has put a question out here? Oh, I'm sorry. We had somebody who had an audio issue. I apologize for that. I did not see my questions until I just turned that on. Hopefully if you went, the person who lost the audio, obviously you're not hearing me, but if it was restored in some way, everyone is going to get a copy of the slides here. We're going to email those to you. So if you missed something or couldn't take notes or didn't want to take notes, you will be getting those slides. Let's see. Yeah, that's right. I'm sorry. Corbin is sitting here. I said she was my silent partner today, but she just reminded me of something important, that we're also going to post this entire broadcast on the webinar on our TowneBenefits.com site. And we got somebody that said, thank you. They liked the podcast. I mean, they like, oh, hey, awesome. Somebody gave me some feedback on the podcast. Woo-hoo, so glad to hear that. And that's it for the questions. So hopefully that meant that it was thorough enough to give everybody a good idea of this this new law. And as always, we deeply appreciate our clients. We try in every way to help people, give you personalized attention and personalized service, help you answer your questions, and periodically do things through electronics to, just kind of reinforce all that. But again, Corbin and I always welcome your feedback. We welcome any communication that you have with us. And until next time, I would just say we'll sign off now and hope that you have a wonderful rest of your week. And hopefully this weather is going to continue. And if you've taken a vacation, we hope you enjoy that as well. Thank you so much.